Thank you for watching. This is Vivian King, and you're watching Truth and Justice with Vivian King, where we try to tell the truth about the criminal justice system. Tonight, I have a very interesting guest named Melvin Green. Melvin is on parole, and he says he's on parole for a crime that he did not commit. He got a very long sentence, and he wants to talk about his crime and vent a little bit about why he said he didn't do it and about the law that convicted him, the law of parties. We'll take you through his life a little bit so you'll have a little bit of background about him, and then we'll get into the case in which he's on parole for. In fact, he got permission to come talk about his case tonight, and we're very happy to have him talk to you tonight. Hopefully, I'll have very interesting callers, and we'll be able to learn a little bit about the criminal justice system. He's on parole for aggravated robbery, but I want to right now introduce you to Melvin Green.
Yeah, this is Melvin Green, and I've been convicted, as Ms. King said, to aggravated robbery. I was convicted under the law. I was supposedly be convicted under the law of party. However, that's what makes my case very interesting because in reality, I was convicted as the primary actor. And
well, let's talk about a little bit of your background, Melvin. Where are you from?
I'm from Houston, Texas. I grew up in the Heights area and partially in Sunnyside area.
What school did you attend?
I attended I attended 8th Avenue as an elementary school. I attended Harper Junior High, which is in 6th Ward at that time, and then I went to Booker T. Washington, which is in the north side of Studewood.
So tell me about the first case that you got.
The first case I got in trouble was a 1966 allegedly to breaking in a motor vehicle. I received 15 months in the Department of Criminal Justice, and I was released, I think, within 7 months.
Then what's your next case?
My next conviction came from a crime that took place in 1969 where I shot an individual and I received 10 years, again, in the Department of Correction.
Now tell me, you told me off camera that you felt bad about shooting the guy. Tell me about that. But you had a reason for shooting him because he and his friends jumped him.
Well, I was mistaken for another guy that has the nickname that I have, which is Popeye. And several guys had jumped me, and because they felt like that I had took some money from one of them, and I just had came back in town, and I was really upset of the fact that 6 or 7 guys jumped on me. I hadn't done anything, so I let my pride get involved, so I went and caught one of them and I shot him. I received 10 years. I did because I knew the fellow, I knew his family, and it was just an awful situation. But anyway, I went.
But he lived, and he's not paralyzed or anything.
Oh,
right?
no, it wasn't to that extent. He lived and perhaps had a great life of his own thereafter, you know.
But at this point, you have 2 felony convictions, so if you get in trouble again, you're considered a habitual.
That was correct. I was considered a habitual, so I ended up getting a theft case.
And that was in 1977 or 1979?
77.
77, okay.
I was convicted for felony theft, Harris County. I received...
Tell us about the theft. It was, you said $400 and something. Tell us about that.
Yeah,
I
allegedly to have stole $480 out of a cash register, out of a store.
Okay.
And I received a life sentence, which they filed habitual criminal, like you say, it was due to 2 prior felony convictions that I just spoke of.
Okay, so they gave you life in prison for stealing $480. Nobody was hurt, wasn't an armed robbery or anything. It was just snatching $480 out of a cash register. Is that right?
Yeah, it was just actually stealing. It wasn't no snatching. It was just actually reaching my hand in there and stealing $480.
Okay, and now that's actually a misdemeanor, but
yes.
Even if you're habitual, you couldn't go to prison for that because it's a misdemeanor offense. But back then, $480 was a felony, and because you had 2 prior felony convictions, You were facing 25 to life. So you were given life in prison by a Harris County jury
That is correct.
in 1977 for stealing $480.
Right.
And because of your two priors.
Right.
All right. And so how long did you stay in prison for that?
I stayed in prison for 8.5 years.
Okay.
I was released in '86. And in '88, I was accused of this crime.
Okay, let's get to that. So in '88, you were accused of aggravated robbery, which for our viewers means robbing someone at gunpoint, knife point, with some deadly weapon, and taking or attempting to take their property with a deadly weapon. One of the things that will be interesting for Melvin is that he said he was convicted under the law of parties, and we'll get into that as he tells his story. But Melvin, it's your position that you're innocent. You didn't do this aggravated robbery in 1988. Is that correct?
That is correct.
However, so as you tell us the facts tonight, it's going to be based on what the witnesses testified against you in trial. Is that right?
That is correct.
Now, did you have a court-appointed lawyer, or were you able to hire your own lawyer?
I had a court-appointed lawyer. His name was Kenneth W. Smith.
And did Mr. Smith read the police report to you prior to you going to trial?
I think he did.
Do you think he investigated the facts? I mean, did you have what's legally termed an alibi, which means did you have a place where you were?
It was determined later through an investigator that it was a strong possibility that I was in Dallas, Texas when the crime took place. However, that did not substantiate an alibi due to the fact that it was also learned that I had registered in a motel in Lancaster, which is in Dallas County, in a motel under the name of Robert Fuller. Even though my vehicle and my signature was there, under the advice of Mr. Smith, he advised that that wouldn't be a good enough alibi due to the fact that I wasn't in my name.
Why did you not use your name, Mr. Green?
Well, it's just a bad habit of have been involved in crime and know things happen, checking in motels. You might be checking in one that something already done took place, or you know, drugs or whatever may be already in there. And it just gives you an opportunity to maybe get away from something, you know. It was a bad habit.
When you checked in back in those days, did you have to use an ID that matched the name, or
No, you did.
They didn't care about that?
No, you didn't. They basically just registered as long as you had the money to pay the fee that they was asking. They pretty much would let you stay in a motel, you know.
Did you check in with a lady friend or any friends?
At that time, I had a friend with me, but he lived in Dallas, and he went to his own house, and I just happened to check in the motel. So no, I had no companion with me.
Okay. All right. So you were in Dallas, but you couldn't prove. Well, you could prove it, but you were under an alias name, so it was going to be hard to prove.
Right.
Now, were you also using an alias name because you were on parole back then, and you weren't supposed to leave the county? Could that be a reason? Back then, I mean, that would have been something old.
No, because my conviction was in my name,
Right.
so I couldn't. That wouldn't have been appropriate there, you know. The conviction that I had got the life sentence for theft, it was in my name.
Okay. All right, so let's talk about the aggravated robbery. So what did your lawyer tell you before you went to trial? Were they making you a plea bargain offer, offering you some time instead of going to trial?
Yeah, they offered me 30 years to plea. And quite natural, I wouldn't take 30 years. I was on parole on life. I wasn't going to take 30 years because I hadn't committed a crime. And I was certain that in trial I'd be able to prove my case. However, Mr. Smith, in my opinion, was ineffective, very ineffective. And as we discuss this case, perhaps it would be recognized that he was ineffective.
Why do you call him ineffective? That's a legal term. Tell us what happened for you to call him ineffective.
Well, he did not investigate this case properly or appropriately, nor did he know the law. Being an attorney, he seemed to not really was familiar with the law party. He seems
Let's not get into that until the end. Let's talk about the plea bargaining. So in the plea bargaining stage, your lawyer has nothing to do with that because the DA makes the offer, and your lawyer has a duty to relay that offer to you.
That's true.
And so you have to decide whether you're going to accept that offer or not accept that offer. So you said no, let's go to trial.
Right.
All right, so tell us about the facts of the case in the trial. What happened?
Well, okay. First of all, in 1988 of June, I was coming down Airport Boulevard in Houston, Texas, with a young lady in the car with me, and we had a heated debate about something we was arguing about. And airport policeman was headed northbound on Airport Boulevard. I was headed southbound. And he decided to turn around and stop me. He testified in court that he stopped me because he had noticed that I was driving on a slow rate of speed. And he wanted to see if anything was wrong with the vehicle or the person was in the vehicle, which was me. And he pulled me over and obtained driver license, insurance, which was all valid. Sticker on the car was valid. He also made me aware of the fact that I might have had a crack in my taillight lens. However, he called in. He called on what they call a 5521 check, I think it was. He called in and see that I have any warrants or anything, outstanding warrants or whatever. And it came back over the radio that I had 2 outstanding warrants for tickets. At that point, the officer placed me under arrest. He determined what would happen to my vehicle, and after that, he requested another airport officer take me to 61 Reasons, which is Houston Police Department, going to jail for the 2 warrants of the tickets. While we're en route, going to jail, it came back over the radio to bring the suspect, which was me, to the robbery division because I may have warrants also in robbery division. And the officer followed those instructions, took me to robbery division. When I got there, there was a detective that approached me and say, his first thing he asked me, had I ever had a gold in my mouth? And I told him, no, I never had a gold. And I asked him, why would he ask? He said, well, that's the kind of description that we get in this report. He said, would you be willing to take 2 pictures for identification purposes? And I told him no. And I said, I would like to have an attorney. No, and kind of, he propositioned me. He said, well, I tell you what, if you take the pictures, if you can't be identified, then I have no reason to charge you, and I'll let you go. And so I still said no because I didn't think that was right. And a little scuffle kind of broke out, and I said, well, I'm headed the wrong way with this. So
Why did you scuffle with the police? I don't understand that. To get out of the room, or why were you scuffling?
No. They was trying to get me to stand up against a petition.
So they're pulling you against a petition.
Right. They kind of using a little bit of force, not, general force, to get me to take the photos. And I don't want to take the photos for the reason that that type of identification, I'd already know that I thought the airport policeman had already illegally arrested me. So they ended up taking the pictures, and he come back and he say, well, they wasn't clear. Would you be willing to take 2 more? I said, well, why not? So I took 2 more photos. And when he came back the next time, he told the airport policeman to lock me up, to file aggravated robbery charges. I'm going to take me downstairs and lock me and file charges. So, and that's what happened. So after that, I was transferred to the county jail. And at the county jail, which was about a week to 2 weeks, they staged a lineup. That lineup was consisted of other inmates that was in jail with me, not necessarily in the same holding area with me, but they was in jail with me, and they held the lineup, and the witnesses, which I later learned was the complainant and state's eyewitness, they identified me. The complainer identification, to my knowledge, was tentative. And you may want to explain that to your viewers what tentative means, since we kind of using a legal term. And the second witness identification was positive.
What I do want to explain to the viewers is that this happened at a convenience store off of 45 North in the Feeder Road, and this is a convenience store robbery of, we'll call him the complainant, but he does make an identification. And then there's a second person, owner of a lingerie store in the same strip center, that also says he sees and identifies Mr. Green as the robber. So there's going to be complainant number one, who is the actual store owner, and then there's going to be the eyewitness, as Mr. Green calls it, which is actually a lingerie owner. So explain a little bit about how they set that up, though, for the viewers.
How
the witnesses, right? Well, how the actual location was set up in the trial, you know, because you said it was shaped kind of like a horseshoe or an L.
Yeah, it was they used a diagram that showed that the strip center was in an L, like the store was like on this end of the corner, and the eyewitness place of business, which was the laundry, it was at this part of the strip center.
Okay.
And what had happened was the eyewitness said that he noticed that I had backed my car into the strip center. He identified this particular vehicle as a dirty gray General Motor vehicle with me driving, and I think he said a 5'10", 160-pound individual was with me, who wore a warm-up suit that he felt like in June was kind of unusual because it was kind of warm, and that was kind of out of the ordinary. So he begins to watch what happened. He claims that I went to the end of the store and got a paid telephone, and I was talking to someone, but I kept looking back at the vehicle that I got out of. He said it was in his opinion, he thought it was some kind of drug trafficking going on, some kind of drug transaction was going on. And the next thing he looked up, that we was leaving the shopping center, and the complainant was shooting at us. But now, what becomes strange here, they put me with two different vehicles and two different individuals. And that is strange, because the complainant, the one that got robbed, said that a 5'4" individual robbed him, and I was the driver of the vehicle, the getaway vehicle. As I just stated, eyewitness said that I had been with a 5'10", I was driving that vehicle. So that was the strange part of the case right there.
Hold on, we're going to take a call. Thank you for calling. Call, you're on.
Hey, how you doing there, Ms. King and Mr. Green?
Hey, how are you?
How you?
I'm doing good. I just tried to let you know that I've been watching you, and I call you every week, I guess, you know, I'm kind of hooked on the show.
Thank you.
I missed one episode. I feel real bad about it. I caught you on YouTube, one of the episodes I missed.
Thank
But
you.
you're on YouTube.
Yeah, my secretary did that last week. Thank you.
Okay, I want to thank Mr. Green for coming on and sharing the story with us. And that's about all I got for this week. I just want to thank you again for providing all this information to the community. Thank you.
Okay, you need to develop a show for me and call me, okay?
I think I'll do that.
All right, well, keep watching tonight, and if you have any questions, call me back.
Okay.
Thank you.
Bye.
Yes, and so we go to court with this case, and now we're in court. Those two individuals' identification becomes a little suspicious because
Just a moment. Oh, okay.
because they could not get it right. In other words, the complainer could not, during the lineup, the complainer that got robbed could not make a positive identification of me. The eyewitness did. When we get into court, it's kind of switch a bit.
Now let me stop you first. The complainant, who's an Iranian store owner, identifies you in a lineup that is done with you and 5 other people live at the jail, just other people in the jail, and they call it a tentative lineup. And let me explain that. There is a positive lineup, positive identification. That means I'm 100% sure that's the person. There's a tentative identification, which is not 100%. So generally, DAs are not going to go to court with a tentative, because a tentative is already reasonable doubt. It looks a little bit like the guy, but it's not really him. Then there's a negative ID where that's just not him. So the police have 3 categories. So the owner of the store tentatively identified Mr. Green in a lineup, meaning he wasn't really sure, but it looked like the same guy. And then the other eyewitness, who is the lingerie owner in the same strip center, does a positive identification, because he's the one that told Mr. Green, said that he saw Mr. Green at a payphone in the area, and thought he looked a little bit weird. And so he's saying he noticed it. But the question is, though, did the second eyewitness, which is the lingerie owner, did he say he actually saw you and the other guy do the robbery? Or did he just say he saw the car suspiciously in the parking lot?
Well, that's the strange part, right? He never did testify that he could testify positively that I robbed anybody. His testimony was I was on the phone. His testimony was that he got my license plate number off this dirty gray General Motors vehicle.
Right, and let's talk about that too. So he says that he got his license plate number off this dirty gray General Motors vehicle. And General Motors, you talked about, could be several cars. It could be Cadillac, Chevrolet, Oldsmobile, but that's not the kind of car you had. What type of car did you have?
At that time, I had a 1983 Midnight Blue Park Avenue that was purchased from Bob Marco Buick, which was on the Gulf Freeway at the time. One of their representatives came and testified to the extent of that vehicle they sold to me. At no time in my trial did either witnesses identify that particular vehicle.
Okay. So how do you think that your license plate number was written down? You think the guy wrote down the wrong license plate number and it came back to your car because your car didn't really fit the description. You do have a big car, but it's the wrong color. So how do you think that happened?
Well, I hate to get into opinions, but my opinion is that I think a little bit of information was shared from the law enforcement, from the detective that investigated the case. Okay. Because if you recall, my particular vehicle from the get-go was supposed to be a suspicious vehicle, meaning that it had possibly been involved in other crimes, and the information from those crimes were obtained is the same information that led to this crime. And this is what makes this crime here is a bit really odd and suspicious.
Let me get another description. Actually, the convenience store being robbed, the complainant is Iranian. He describes a 5'4" man going in, actually robbing him, and he describes you as the lookout guy. And you're 6'1", standing at the door and also driving the car. Is that correct?
That is correct.
And then the eyewitness that owns the lingerie store identifies you as the person standing at the payphone, looking suspicious, trying to say that maybe you were looking out, but also describes a 5'10" guy as going into the convenience store. Is that right?
Yeah, he described that a 5'10" guy was with me and possibly went into the store, but there's no other information after that this individual committed any kind of crime.
Well, let's hold that thought and let's go to what actually happened in the store. What did the store owner say happened? Because I want to lead back to the second witness later.
It's my understanding, well, he testified in court that some unknown 5'4" guy came in the store the day before. And he felt like at that time he was casing out the place. When he saw him again the following next day during the robbery, then he knew he was being robbed.
But how did he know he was being robbed? The guy had to put a gun in his face?
Yeah, but that's what he's saying. The guy put the gun in his eye. He trembling. He telling him something about gave him the money or something. He ended up escorting him to the back of the store, putting him in some kind of duct tape. In the process that he's supposed to have been getting the money, he get her loose. By this time, he's seeing myself and this 5'4" individual leaving this blue car, General Motors, and we driving away. He begins to shoot at this, and
But let me stop you for a moment. So he's saying that the 5'4" guy comes in, robs him at gunpoint. He says he sees someone that looks like you standing at the door, and the 5'4" guy takes him in the back to his personal office, duct tapes him, and puts him in a cooler. Is that correct?
that's what he testified to.
And somehow he gets out of the cooler, breaks out of the cooler, and breaks out of the duct tape, gets to his gun, and shoots at who he says is you and the 5'4" guy. You being 6'1", the other guy being 5'4". And he shoots at y'all in the car. So did he say under oath that he shot the car? Like bullets went inside the vehicle?
It was never determined whether he hit anything,
Okay.
the car or anything. It wasn't determined that.
And what about the lingerie owner? Did he testify when he got in court that he heard the bullet shots of the complainant shooting at y'all? Because if he thought you were suspicious and you, who he says is you, and your associate going into the store and y'all look suspicious, then robberies happen really quickly. So probably within 5 minutes there should have been shooting. So did he testify under oath that he heard shooting afterwards?
He did. He testified that he heard shooting, and he said that also that they were shooting at some kind of blue vehicle. However, he also testified that me and the 5'10" guy got in this great dirty gray car, and we left. Now
once he changed his story to saying it was a blue vehicle, so was he then saying it wasn't you anymore, or was he just going along with what the complainant said, the store owner?
No, the store owner wasn't saying about the blue vehicle.
Okay.
And the lingerie guy that owned the other store is talking about the dirty gray vehicle that he got the license plate number off of, which is two different vehicles.
Right, but let me make sure you understand my question. I'm asking you, did the lingerie owner say that he then subsequently heard gunshots?
He did.
And he said he heard gunshots and he saw shooting of the Iranian store owner at a blue car.
True.
So that means the lingerie owner described two different cars, the gray car that he took license plates off of, and then he just talks about a navy blue car, a dark blue car that he sees getting shot at, but he didn't try to write the license plates off of that car.
No, he did not.
Because it seems to me that would have been the getaway car, and that would have been the car that actually is doing the crime. But he didn't say he got the license off of that one.
No.
He got a license off of a car that's not involved in the robbery.
True.
Okay.
And it's prior to the robbery ever taking place.
Okay, I just want to make sure I'm straight on that.
Right.
All right.
And so at that point, we're in trial, and all this is coming up now. What's strange about the case is, like I say, I was arrested by airport policemen, and it's supposed to have been on the arrest warrant. We go to trial, you have motions hearing before you start the trial, and those arrest warrants were never produced in my case.
And let me tell you why this bothers Melvin, because his lawyer had to file a motion to suppress the evidence because the Constitution says every person is free to be free. The Fourth and Fifth Amendment talk about our right to be free and to be left alone unless there's a search warrant or a warrant for his arrest. And so what he's saying is that he filed a motion, his lawyer filed a motion that he should have been let go and not arrested under a warrant unless it's actually produced. So you have to have a warrant according to the Constitution, and it also has to be produced. It can't be hearsay. And in Melvin's case, what he's saying is that in 1988, when he had a motions hearing on the Fourth Amendment, unreasonable search and seizure, that no warrant was ever produced. And even if it's a city warrant, it has to be produced in court.
Right.
And even though it was never produced, the judge still denied the motion to suppress. Well, in fact, it shouldn't have been denied, and that's one of the problems that you have, right?
That's a big problem because the evidence that's obtained after an illegal arrest is what they call tainted. And in most cases, most lawyers would object to it every time it's entered into the case. Every time they present it, they would object to it to preserve the error
Now, keep in mind, Melvin's been in prison a long time, and what I told him is that we're going to have to break it down because, you know, when people go to prison for a long time, they learn all the legal terms, which everyday people don't know. So let me try to translate the legal jargon that Mr. Melvin Green is going through. So he's saying that to him, because the original arrest warrant when he was driving down the street was never produced, the judge should have sustained his objection, saying throw it out, there was no warrant, he shouldn't have been arrested. But the judge didn't do that. And if the judge had done it, though, anything after that is determined to be that the evidence is tainted, T-A-I-N-T-E-D, tainted, and it's the fruit from a poisonous tree. And if it starts off, if the tree is poisonous, all the fruit that bears after that is poisonous, and it should be thrown out, including he shouldn't have been in a lineup. He shouldn't even be here. That's his problem. However, in Harris County, the judges rarely sustain an objection or a motion to suppress. That's what we learned through the years. So I wasn't there. I don't know what happened in '88, but this is what Melvin is upset about. So there was no warrant produced, which should have been easily produced because we were definitely in a paper environment in 1988. And so it should have been produced. They even produced the paper now in 2012. So the paper wasn't produced. The judge still allowed all of the evidence to come in, and Melvin's upset about that because from there he's put in a lineup, and he just becomes a suspect because of this license plate on a car, but it doesn't meet the physical description of a car. And the lingerie owner who gets the actual license plate number on a gray car later describes seeing the convenience store owner chase at and shoot at a convenience store. I mean, at a navy blue car, which he didn't get the license plates off of that. So Melvin's upset about that. Let's try to take a call. Oh, no call. I missed you, sorry. So, do I have a call? Thank you.
So,
call back if you hung up. I'm sorry.
So now, this translates now into an indictment. And the indictment in this case, I just wanted to read a bit of it. It say, hereafter, style the defendant, heretofore, on about April 21st, 1988, then and there, unlawfully, while in the course of committing theft of property owned by John Doe, hereafter styled the complainer, and with the intent to obtain and maintain control of the property, intentionally and knowingly, threaten and place the complainer in fear of imminent bodily injury and death.
Imminent bodily injury.
Right. Body injury and death by using and exhibiting a deadly weapon, name and firearm. Now, this is very important. Now, this is how I'm indicted. Now,
let's talk about something else. So he's reading the indictment, which basically says that Melvin Green put the store owner, the complainant, in fear of imminent bodily injury or death by exhibiting a deadly weapon and attempting to take his property. Now, in aggravated robbery, the crime does not have to be complete. You don't have to actually take the actual property. Right. It's just if you put the person in fear with a gun and they appear to acquiesce to you. In this case, I think money was actually stolen, but that is an aggravated robbery. There has to be a deadly weapon, and the person has to be in fear of their lives. So that's what he's reading, and because that's when whatever's in the indictment, the state of Texas has to prove that beyond a reasonable doubt in a trial. So in the trial, the state produced 4 witnesses. The first one was a complainant that owned the store, who gave a tentative ID at the lineup because he said his facial features didn't match as much, and the lineup was just done a few days after, about a month after the alleged crime. And then there was a in-court identification where the store owner said it was him. The second witness for the state was the lingerie owner, who said he was positive it was him both times at the lineup.
No,
he was positive at the lineup, but he was not positive in trial.
Right.
So basically in trial, you have only one witness, the complainant, saying he believes it's him for the jury to believe, because the lingerie owner changed his opinion, and he became tentative when he saw him in court face to face. And then there were 2 other witnesses that I'll let Melvin explain.
Yeah, the other 2 witnesses was airport sergeant who originally arrested me
So he wouldn't be really relevant to anything but the arrest because he didn't see the robbery, but I guess he did think that you matched the description, or your car matched the description, because he had to transfer you over to the robbery division, right?
Well, no, that wasn't, no.
What was the essence of the airport
Well,
police
the essence of him, you remember, he arrested me on outstanding warrants.
Right.
That
So
was,
he was the essence of, he was the motion to suppress.
right.
Let's take this call. Call your own. I'm sorry I disconnected you before.
Okay.
You have a question?
Yes, ma'am. My question is, if you live with somebody in a household and you go to jail, where my niece called the police on me, and went to jail, and I live with somebody, and then I had to get back in the house. I broke the window to get in my house, but I'm not on the lease. But but I've been living there for 2 years, and the office managers know me. Is that a burglary habitation?
Well, I can't give legal advice over the phone, but hypothetically, it's a burglary of a habitation if you break into someone's house without their permission.
Okay, but I got mail here, and I've been living here for 2 years.
I'm not going to talk about your case, but I'm just going to say hypothetically,
Yes,
if a person, if it's my house and you've been living with me for 2 years, and you break my window, and I say you have no permission to be in my house, then
Okay, but
technically
that
it can
wasn't
be.
said, though. I wasn't evicted or nothing like that.
Well, I'm just telling you, technically, since it's my house, if I have a lease or if it's actually my physical house that I own, I can say who can come and who can go. So
Okay,
if
I
but
understand,
but
ma'am.
I would have to testify against that person in trial. So if it's a relative or someone I've been having stay with me for 2 years, I
Yes,
might
ma'am,
say
it's my mother that I've been living with.
I might say, I'm not talking about your case, I'm just saying hypothetically, I would come to court and say, or tell the DA, hey, I gave him permission to come in. I didn't want him to break the window. I'm going to make him pay for it. But I gave him permission to be here. He does live here. So
Okay,
it's up to,
alrighty, ma'am.
hypothetically speaking, it's up to the person who owns the house as to how they want to characterize it as a burglary. I can say that I'm mad at him for breaking the window, but technically, he does live here.
Okay, all righty. Well, thank you, ma'am.
That
okay?
can happen. Now, tell me what you think about Melvin Green's case, though.
Well, ma'am, you know what? I done been in the penitentiary 3 times, and I swear to God, I was working on a job, and when I was working, them people went 18 years back on my prison record and let me go.
After 18 years?
Yes, ma'am, and the Bank of America, that the people that own this place, they had hired me. I was working maintenance for 3 months, but some people out of Dallas bought this place, and when they bought it, them white, I'm excuse my language, them white folks went back on me 18 years and looked up my prison record and released me.
Well, let me just tell you the good news. You have 18 years of working, so keep
No, ma'am, I ain't.
No, I'm just saying. I'm just saying you had
a prison record that they
Right.
went back all the way 18 years on me.
I got you. Well, unfortunately, and this is what I tell young offenders: don't plead guilty to your first offense just to get probation if you didn't do it, because it's going to follow you for the rest of your life. If you're 65 years old, like Mr. Green might be, it's still following him.
I'm only 48.
But it's going to follow you forever. But keep up the good work. Someone will hire you. You sound like
well, thank you, ma'am.
You sound like a hard worker. Somebody will hire you.
All right.
Okay. Good luck. Okay, Mr. Green.
Yes.
So we were talking about the indictment. We were talking about the first 2 witnesses, and then the third witness being the airport policeman that basically testified that he saw a warrant on the computer, or it was prior to computers, but he called in, and when they called in about you, they found out you had outstanding warrants. So his burden was to produce those warrants in court, and he didn't do it. So who was the 4th witness for the state?
The 4th witness was a robbery detective who testified that that case was given to him on May the 10th of 1988.
Now tell me why you think that's significant, May the 10th of 1988. Was it alleged to have happened when? In May, right? I think May the
No, actually, according to the indictment, the case happened April 21st, 1988.
Okay.
The detectives say the case was given him on May the 10th. I was arrested June the 17th for the outstanding warrants. And then later charged. I was placed in jail of aggravated robbery. Now, everything done changed. I didn't go to jail for the original detainment that the airport policeman done, which was based on the 2 traffic ticket warrants that he called in on. That was the report he got. Now, to kind of skip a little bit because we push for time, is that I go to trial, and after we hear, like you say, the judge overrules the motions, the suppressed motion, identification motions, and all the rest of the motions that was filed, he overrules them. We go to trial. So now these people here really can't testify to what happened on April the 21st.
Right.
Only someone can testify what happened on April 21st is the complainer, who said he got robbed by a 5'4" guy, and I was the lookout guy in the getaway driver.
Now let's talk about that. So the complainant is really the only evidence they have when it comes down to the trial, and he says the 5'4" guy robbed him at gunpoint, duct taped him, put him in the cooler, and that he described someone that looked like you as a person at the door and the getaway driver that he shot at. Is that correct?
That is correct.
So one of the things I know that after the evidence is all in, the judge has to give the jury the jury instructions or the law on the case. And in this case, one of the things that Melvin's upset about is they gave him the law of parties, which is in our penal code 7.02. And it's basically says, and if I don't have that right, it's 6.02. But anyway.
No, it's 702.
It's 702. Okay, 702. All right, I thought I was right, but anyway. So under the law of parties, it says that one person can be criminally responsible for the acts of another. Okay, so that means that I can be criminally responsible for Melvin Green's act if I aid or abet him in any way or do anything to help him complete the crime. So, for example, if I gave the 5'4" guy the gun, but I wasn't there, that's aiding and abetting him under the law of parties. And I know, but I have to know that I'm giving him the gun to go rob this convenience store. And when he robs a convenience store, if somebody gets shot, I can actually be charged with him under the law of parties. If the jury believes beyond a reasonable doubt that I had the same mindset and the same agreement and I aided in any way. So that's how lookout drivers are charged. Lookout people are charged. So say the person who was standing at the door while the person with the guts and the ballsy one went and robbed somebody, everybody gets charged the same. Even if you stay in the parking lot with a getaway car and they go in and rob a bank and shoot somebody, everybody gets charged with the same crime. So what's confusing and what a lot of lawyers do not explain to their clients is that if we go to trial on this, the jury is going to come back and say guilty as charged in the indictment, which is what they said in Melvin's case. And Melvin's upset about that because he didn't understand that and still has a problem with the fact that the indictment says that Melvin Green is the person on April 21st, 1988, that actually put the store owner, John Doe, in fear of his life, imminent bodily injury or death with a weapon. And Melvin Green says, not only did I not do that at all, he has a problem with the fact that he's doing all this time under the law of parties. Is that correct?
Yes, that is very correct. However, I would challenge any attorney about what you just stated.
Well, what's your challenge, Mr. Green?
My challenge would be this here. In the jury charge, I was charged as the primary actor and as on the law party. Now, at best, the state case rests on the law party. The burden of proof was greater for the state to prove that no way could have been, they didn't object to the charge and lessen their burden.
But let me just tell you this. Under the law, though, there's going to be 2 charging paragraphs that goes back to the jury when they deliberate. You can believe he's the actual actor that did it, and if you believe he's the one that actually performed the robbery that's in the indictment, beyond a reasonable doubt you can find him guilty. Or in the alternative, if you don't think he did it himself, you think that he was criminally responsible for the act of the 5'4" guy. There were agreement that the 5'4" guy would actually do the robbery, and he would stand there and aid and abet him by being the lookout in case the police or someone came in, and he also would be the getaway driver. Then you can also find Melvin Green guilty if you believe it beyond a reasonable doubt. That's basically the law of parties, which gets a lot of people, especially young people, that go in
But in my case here, they got to be a little more specific.
Okay, what they do?
Why? Because at the time of my case, there was a case, and we have to kind of use law here. You advised me to try to stay away from that because that complicates your view. However, there was a case called Travesty, in that was
Excuse me, I'm gonna take this call. Yes, caller, you're on. Thank you.
How are you today, Attorney Green? Mr. Green and Attorney King.
Okay, hey, how are you?
Oh, pretty good, pretty good. Love your show.
Thank you.
And I'm not a formidable barrister like yourself. I'm just a layperson. But I was wondering, I've been watching your show every Wednesday, and I was wondering, did Mr. Green have an alibi as to where he was on the date of the crime and at that particular time?
Yes, sir. He had an alibi. He was in Dallas, but at a motel visiting a friend, but he used an assumed name. He used an alias name, and so his lawyer advised him not to present that because it made him look like a liar, basically. You have a comment on that, Mr. Green?
Yes. For some unknown reason, I was in a habit of using alias names during that period of time. And
he was on parole for life, and so he didn't want if something went down at this motel illegal and it was a bust, he didn't want his name to come up, so he used an alias name. So I'm the type of lawyer that if you have an alibi, I'm going to try to use it. And just be honest with the jury. If you did it, just get up there and explain what you did and why you did it, and let the chips fall where they may. Because I believe that a jury is going to think you're guilty until proven innocent anyway. So if you don't say anything, I have one of those philosophies: if you don't talk, you don't walk. And everybody in the courthouse knows that. The old school lawyers could sometimes, because of their magic, win without their clients talking, but I ain't old school. So women lawyers haven't been around that long, and the way I win cases is I have to connect with my jury. So I have to, from voir dire, which is when you pick them, to opening statement, and I make my clients tell the truth about what they did wrong. But if they didn't do it, get up there and convince the jury. You convince me. So get up there and convince them. I don't use the approach of the old school approach, which is what his lawyer did. You don't say anything, and you don't tell them your alibi because, they're not going to believe you. I mean, they're not going to believe you anyway. So you might as well say what happened. What do you think?
Right. And also the law that you guys just stated, I think was 702 or something like that.
It's 7.02 of the Penal Code. I came at the last minute. I've been in trial. Actually, I'm in capital murder hearings until like 5 this evening, and Mr. Green was nice enough to agree because my original guest canceled. So I ran and picked him up because he's one of the viewers like you that called in. So I didn't get to bring my code book, but as I recall, if you Google the Penal Code 7.02, that should be the law of parties.
Right, so it basically says that he was guilty by association.
Basically, that's what it says. As long as
if I give someone a baseball bat, and they walk up to someone else and hit them in the head with it and cause bodily damage, then I'm guilty.
Only if there was an agreement before then. That's one part. You have to know what they're going to do with the instrument you give them. So if you just give me a baseball bat and I go beat somebody to death with it, no, you're not guilty. But if there's some way that the state can prove you gave it to me for the purpose of beating somebody to death, then you're guilty of beating them to death too. But they have to somehow prove that from some evidence that was your intent. If I give him a gun just to give him a gun, no, but I have to give him a gun. And that's like a far-out example that lawyers use just to kind of stretch one's imagination. Generally, it's going to be the lookout guy, but there's another defense that a smart lawyer does and says mere presence is not enough. Because a lot of times with teenage kids and young people, they're 4 or 5 deep. They might be at a party, and half the little bad kids, they're all from 3rd Ward. I live in 3rd Ward. They're all going to a party because some still go to Lamar High School, some still go to Yates, some have dropped out. So they're catching rides. The little bad kids usually have cars for some reason. I've had cases like this. And they go, but they start picking people up, and they go out robbing and jacking people, and then they come back to the party and play. Then they go out jack people, and they come back to play. And then they give 2 or 3 people in the neighborhood rides home, And if they get stopped that night, everybody in the car going to jail. You see what I'm saying? That's a lot of times how teenagers get caught up. They might have been back there asleep and didn't know what was going on, or just caught a ride. And if they were actually there when it happened, but they didn't know what was going to happen, there is a part of the law that says mere presence of a crime is not guilt. So it's not guilt by association, it's mere present. You have to, the state has to prove you took some affirmative step to help that crime occur. So in Melvin's case, it was the lookout or the getaway driver. But if somebody else was in the back seat, they can charge them or they can leave them alone. And so, and a jury has to decide whether they believe that defense or not. I was just there. Because you don't have a duty as a citizen to stop a crime. And you can watch a crime, and you don't have to have a duty to tell the crime. But you do have a right to be there and be found not guilty because you were merely present at the scene.
Well, that's one of those fine lines, I think, in the law, and that's where discrimination, racism can kind of eke its ugly head. And
that's why, as citizens, the urban community has to make the sacrifice of going to jury duty and being fair and impartial, because we are very fair and impartial, and let the chips fall where they may. I mean, you might not have believed Mr. Green. Just because you're black doesn't mean you won't believe him. I mean, you believe everything he says. But then, on the other hand, you might believe him. But it is important that everybody participate.
On one of your previous shows, you spoke about pretty much the judgeships and so forth. But I really think that the office that we really need to concentrate on is the DA's office.
It all works together, because let me tell you why. Say, for example, if you have a judge, if you have a fair judge, then the DAs cannot play shenanigans.
Right.
You know, because a judge is not, so like in Melvin's case, a fair judge might have, if they didn't produce that warrant, they should have granted that motion to suppress, and then everything would have been thrown out. But you have to have courage, and the people of Harris County have to go out and vote for those judges to have the courage. Because the minority community doesn't vote in big blocks, and that's the Hispanic and black community, then the judges have no power. You know, the judges are going to stay on the side of conservatism. But say, for example, if you had a judge that, you know, like me or someone else that is trying to do the right thing for the right reason, I would need the community to support that. Do you understand what I'm saying? And the DAs only get away with what the judges let them get away with.
Lastly, I would just like to know if Mr. Green is going on with his life, and I know that's a huge mountain to get over, but if he's going on with his life, then, you know, how does he actually do that? How do you move on from something as tragic as that? And I appreciate your time, ma'am.
I haven't gotten over it. I mean, I'm trying to deal with life as I go, one day at a time.
When did you get out? Because he went in for 23 years. Uh-oh.
I got out on the 13th of December, 2011.
So he just got out of prison. He's been in prison for the last 23 years.
And for those who may not know, I'm still suffering. I'm on a monitor right now. This is a GPS monitor device, which I've been stipulated to wear for 1 year due to good behavior. Now, to give...
And you're on parole for life.
Right. Now, to explain to your viewers about Law Party, what it states at that time was, with the intent to promote or assist the commission of the offense. And what that really means, if someone else is committing the offense, then I come along. I solicit, encourage, direct, or aid, or attempt to aid another person or persons, then I can be charged with the same crime.
Hold on for just a moment. Caller, you're on. Thank you for calling.
Good evening. How are you?
Wonderful. Thank you.
Listen, my question is, hypothetically, a person in the same situation that this gentleman was in, hypothetically, what type of fees would most lawyers ask for representing the individual like you have sitting across the table?
I could answer that. I think it's on a case-by-case basis. Just call that lawyer and find out. But do you have a comment for Mr. Green?
Just like him to hang in there, and my prayers go out to him, and hopefully we will go out and vote, and hopefully these things will be curtailed in the future.
Thank you so much for calling, and please join us next week. One of the reasons why people on parole, like Mr. Green, had been on parole from life since '77, I mean, usually you can't afford to hire a lawyer, so you have to get a court-appointed lawyer. So he had a court-appointed lawyer then and on his appeal, and he lives with relatives now. He's on the GPS system, monitored through parole. He's on parole, got permission from Parole to share his story for the educational purposes of our community so that we can spread the word. I'm going to take one more call, and then I'm going to let him say what he wants to say. Thank you for calling.
Yes. I would like to ask Mr. Green, did he do that crime, or is he trying to just get off? Is he just trying to get off with something because his conscience is bothering him? I would like to know that, because I've seen quite a few things in my life, and I've heard people not tell the truth.
To answer your question,
I want him to, did he do this thing?
Now, we're getting that reverberation, we're getting that back feed, so turn your volume down, and I'm going to let him answer that question. Did you do it, Mr. Green?
To answer your question, no, I did not commit this crime.
Where were you, Mr. Green, when this crime happened on April 21st, 1988?
Due to an investigation, we learned that it was a strong possibility that I was in Dallas, Texas at the time that this crime was committed.
And, ma'am, you have a good question, because when I picked him up today and brought him over, I asked him, I said, now, you just trying to, when you got out on parole, because he did 23 years, from 88 until December of 2011, did you have to say you did it to get out on parole? Because I don't do parole law.
No, I did not.
And he said he did not have to admit that he did it. So he's maintained his innocence all along. It's not going to be much he can do about it. It's hard to fight in a writ, and I'm not sure he's even doing that. He's on parole for the rest of his life.
Well, me personally, I think I have a good case here due to the fact that
Ma'am, you have another question? We're going to wrap it up. We have 1 minute.
Yes, I would just like to say one thing to him. He needs to, if he didn't do this, he needs to free himself up and go on live his life. Because all of that he's doing, he'll be dead by the time he gets the system he's not going to get any money.
Right, and he's 65, so it's time to move on and just stay free.
Just go on and have a good life, buy you some soda and have a good life, go get to the park and go on. You shouldn't have been using a bad name anyway. You messed that up when you did that.
Thank you for calling,
I'm
please.
sorry to say this, sir, but I love you anyway, but...
All right, thank you so much for calling. Call us next week. We have 1 minute. Please wrap it up. Tell me your wrapped up comments. This hour goes by fast, Mr. Green. I think the viewers understand the law of parties, and they understand that you didn't do it, and whether you did or not, the law of parties was educated them on. But the issue in your case is not really the law of parties. Yours is that I didn't do it, and I was not the lookout person.
Well, that's
right?
true, but for the interest of justice, it produced a wrongful conviction, and the reason for that is the verdict. In the jury's verdict, it should have read to show that, hey, we the jury find that an unknown 5'4" individual robbed John Doe, and during the commission of the offense, we find that Mr. Green assists and promote by being the getaway driver and lookout man, whatever, and that's how it should have read. Now, that has a real effect because we're talking about parole eligibility. It also stated in Trevor's case with Polk case that it has to specifically say who used the firearm.
Well, let's stop, and we have to wrap this up. Thank you for the stimulating conversation. Callers, thank you for calling in. Mr. Green, thank you for sharing your story to educate the viewers, and we can have you on later on in the year if you want to talk more about this case. Thank you so much for watching, and please tune in next week when I'm going to try to have a tax fraud case on. So watch us next week. Thank you so very, very much.
Thanks for having me.